Judge Boasberg doesn't judge cases involving President Trump impartially. He has made it clear time and time again in his rulings and his comments that he, instead of wearing that black robe, wears, in fact, a blue jersey. He has continually abused the power as chief judge in 5 separate ways. 1, forcing himself onto hot-button cases. 2, abusing his power in the judicial conference to fear-monger to the judiciary about the specter of a non-existent constitutional crisis. 3, rubber-stamped gag orders on subpoenas against U.S. senators. 4, trying to hold DOJ lawyers in contempt for a case the Supreme Court said he had no jurisdiction over. And 5, he sits on the Circuit Judicial Council, which would be able to overturn any disciplinary action taken against him, interestingly. Article 3 has not policed itself. That's the reality. We have to be able to check a rogue judge through the impeachment process.
This may look like another partisan clash over a controversial judge, but it's actually a stress test of how much power unelected courts can exercise without consequences. What's really being tested here is whether the judiciary still operates under meaningful checks or whether internal control has replaced public accountability. This raises broader questions about what happens when judges become both the referee and the rule maker. In this video, we'll break down how a single courtroom dispute has turned into a constitutional fight over who truly polices judicial power in America.
Thank you. Senator Schmitt.
Thank you, Mr. Chairman, and thank you for calling today's very important hearing. I think this is an issue very important to the country. And I want to focus specifically, I'm going to kind of try to stay on script, to stay on time, on Judge Boasberg, who is the embodiment of a rogue judge, which I think is the subject of this hearing. I have a few questions. Of course, I called for his impeachment, and I want to use this time to sort of explain why. Mr. Chamberlain, why do federal judges wear black robes?
I actually don't know the answer to that.
Well, it's to show, I think, impartiality, right? They're certainly not wearing red jerseys or blue jerseys. They wear them to symbolize the impartiality that's supposed to come with that very important commission. And do you know what color robes Judge Boasberg wears in the courtroom? Do you wear?
I would assume they're black.
Well, it turns out it's probably blue, and I'm going to explain why. I'd like to enter into the record, Mr. Chairman. The Department of Justice July 28th judicial misconduct complaint against Judge Boasberg, which reads as follows. On March 11, 2025, Judge Boasberg attended a session at the Judicial Conference of the United States. While there, Judge Boasberg attempted to improperly influence Chief Justice Roberts and roughly 24 other federal judges by straying from the traditional topics to expand on his belief that the Trump administration would, quote, disregard rulings of federal courts, end quote, and, quote, trigger a constitutional crisis. This was on March 11th. What happened on March 15th, Mr. Chamberlain, later that week? That's right. Judge Boasberg issued the turn the planes around order just a few days after that. Within the next week, Judge Boasberg was acting on his preconceived belief that the Trump administration would not follow court orders. Although he lacked authority to do so, he issued a temporary restraining order preventing the government from removing violent Tren de Agua terrorists, which the Supreme Court, by the way, summarily vacated shortly thereafter. Not only that, he forced his way onto the case. In the dead of night, while he's on vacation, Judge Boasberg abused his power as chief judge to force himself onto that case. Judge Boasberg doesn't judge cases involving President Trump impartially. He has made it clear time and time again in his rulings and his comments that he, instead of wearing that black robe, wears, in fact, a blue jersey. He has continually abused the power as chief judge in 5 separate ways. 1, forcing himself onto hot-button cases. 2, abusing his power in the judicial conference to fear-monger to the judiciary about the specter of a non-existent constitutional crisis. 3, rubber-stamped gag orders on subpoenas against U.S. senators. 4, trying to hold DOJ lawyers in contempt for a case the Supreme Court said he had no jurisdiction over. And 5, he sits on the Circuit Judicial Council, which would be able to overturn any disciplinary action taken against him, interestingly. Article 3 has not policed itself. That's the reality. We have to be able to check a rogue judge through the impeachment process, and I don't say that lightly. The House must exercise that power. I want to also note, Professor Luther, it's good to see you again. I appreciate your testimony. You're an expert on the American judiciary and judicial power. Article 3 states that judges should hold their offices during, quote-unquote, good behavior. If a judge then steers a case involving that litigant from another judge to himself by reassigning that case outside of normal procedure, is that good behavior or abuse of the judicial process?
That is not good behavior. There's surely an internal operating rule on how cases are assigned, and to violate it would be a violation of his judicial duty.
If a judge were aware of a federal statute prohibiting him from issuing a certain type of order and then issues that prohibited order, is that good behavior or abuse of judicial power?
I think that's a violation of the judicial oath, so an abuse of judicial power.
On the flip side, if that judge were unaware of the statute, the facts in the case, or the parties being subject to the prohibited order, yet granted the order anyways, is that good behavior or a violation of the Article 3 duty and an abuse of judicial power?
Well, if he didn't know about the rule That's maybe a little vaguer, but we expect our federal judges to be aware of the law, just like we expect citizens to be aware of the law, and we hold them accountable even if they weren't. So in that case, it would probably be a violation of judicial duty.
I just want to close. Chief Justice Roberts said you don't impeach judges you disagree with. You get them overturned on appeal. With Judge Boasberg, this is not about disagreeing with some interpretation of the law. Judge Boasberg has abused his role as chief judge, which are non-appealable ministerial acts. He is a rogue judge. The House should vote to impeach Judge Boasberg based on the articles they have before them. Once the House impeaches, we should hold a trial and hold Judge Boasberg accountable.
Thank you, Senator Schmitt. As I referenced earlier, with no objection, I will introduce into the record, number 1, Judge Boasberg's order. Number 2, my letter urging Speaker Johnson to advance pending articles of impeachment against both Judge Boasberg and Judge Boardman that was transmitted today. And number 3, the record of the Boardman's sentencing decision. Without objection, all 3 will be admitted.
In the final moments of that hearing, Senator Eric Schmitt did not simply argue a point of law. He delivered an accusation that cut to the heart of the American judicial system itself. When he looked into the record and declared that Judge Boasberg was not wearing the black robe of neutrality, but a blue jersey, it was more than a metaphor. It was a charge that one of the most powerful figures in the federal courts had crossed a sacred line, turning from impartial arbiter into political actor. In a single phrase, Schmitt framed the entire controversy. That the robe meant to symbolize fairness had, in his view, become a uniform of allegiance. That moment mattered because it exposed something deeper than a procedural dispute. It revealed a fracture in public trust, a growing fear that the institutions designed to stand above politics are being pulled down into it. When Schmitt entered into the record a judicial misconduct complaint alleging that Judge Boasberg attempted to influence Chief Justice Roberts and other judges at a closed judicial conference, he was pointing to an unsettling possibility that behind closed doors, away from public scrutiny, a narrative was being formed about the future of the country, one that assumed conflict before it even arrived. According to the complaint, Boasberg warned that the Trump administration would disregard court rulings and trigger a constitutional crisis. Days later, Schmitt says that belief appeared to manifest in Boasberg's actions from the bench. This is where law becomes something more than text on a page. On March 15th, just days after that conference, Judge Boasberg issued the now famous Turn the Planes Around order, stepping in to halt removals of individuals the government described as dangerous. The Supreme Court later vacated that order, but the question lingers. Was this simply a legal misstep, or was it the product of a preconceived conclusion about how one administration would behave? Schmitt's accusation was that it was the latter, that the judge acted not from neutral interpretation, but from an expectation of defiance, an expectation he had already shared with other judges. What we saw unfold in that exchange with Professor Luther was a stark reminder of what good behavior under Article 3 of the Constitution is supposed to mean. Federal judges are not elected. They are given lifetime appointments precisely so they can stand apart from political winds. But with that independence comes a heavy obligation to follow the law, to respect the limits of their authority, and to never use their position to steer outcomes based on personal or political belief. When Schmitt asked whether reassigning a case to oneself outside normal procedures constituted good behavior, the answer was clear. It did not. When he asked whether issuing an order prohibited by statute was a violation of duty, the answer was just as clear. It was. This was not, as Chief Justice Roberts once put it, a simple disagreement about interpretation. This was about power, non-appealable acts, administrative authority. The quiet, often invisible levers that shape which judge hears which case, when, and how. Schmitt argued that Judge Boasberg used those levers to insert himself into politically charged cases involving President Trump, to impose gag orders on senators, and even to attempt contempt proceedings after the Supreme Court said he had no jurisdiction. These are not abstract claims. They go to the core of how justice is supposed to be administered in a constitutional republic. And that is why this hearing resonated far beyond the walls of the committee room. In a nation built on checks and balances, no branch of government is meant to police itself in isolation. Congress checks the courts check the executive enforces the law. When one of those branches drifts beyond its boundaries, the entire system strains. Schmitt's call for impeachment was not framed as revenge or partisan payback. It was framed as the last constitutional tool available when internal discipline fails. When Article 3, as he put it, does not police itself. Whether one agrees with him or not, the gravity of what he proposed cannot be ignored. Impeachment of a federal judge is rare, and it is meant to be. It is supposed to be reserved for moments when the integrity of the judiciary itself is at stake. And that is precisely what Schmitt was arguing, that the integrity of the black robe, the symbol of impartial justice, had been compromised. In this moment, the American public is watching institutions collide. A senator accuses a judge of fear-mongering, of predetermining outcomes, of acting as if a future constitutional crisis were already inevitable. A legal scholar testifies that such actions, if true, violate the judicial oath, and a Congress that has often seemed paralyzed is being asked to decide whether it will exercise one of its most serious responsibilities. This is not just about Judge Boasberg. It is about whether the rule of law still means what it was meant to mean. That no one, not even a lifetime appointed judge, is beyond accountability. It is about whether the courts will be seen as referees or as players. It is about whether justice in America remains blind or whether it is slowly learning to look in one political direction. History will not remember the small procedural details of this hearing. It will remember the question that hung in the air when Schmitt finished speaking. If those entrusted with interpreting the law abandon neutrality, who guards the guardians? That question is not theoretical. It is alive in every ruling, every conference, every quiet administrative decision that never makes a headline but shapes the fate of a nation. And so, as this chapter closes, the responsibility shifts from the committee room to the public square. The American system depends not only on laws and courts, but on citizens who demand that both remain worthy of trust. Power, once left unchecked, never corrects itself. It must be challenged, it must be watched, and it must be held to account. If you believe that transparency matters, that justice must be more than a word engraved on a courthouse wall, and that no institution should ever be beyond scrutiny, then stay with us. Subscribe to Liberty Report USA and support our work to expose the truth.